Okay, I think we got it. Sorry about that, everyone. All right, well, good morning on this slightly technically challenged morning for everyone. Today is February 25th, and this is a special meeting of the Oil Conservation Commission. I am Adrienne Sandoval. I am Chair of the Oil Conservation Commission and Director of the Oil Conservation Division. Also with us, would the other commissioners please introduce themselves?
Yes, good morning, everyone. My name is Greg Bloom. I am the designee of the Commissioner of Public Lands, Stephanie Garcia Richard. I am the Assistant Commissioner for Mineral Resources at the New Mexico State Land Office.
Thank you. Dr. Engler was not able to make it today, but I will just note for the record that with two commissioners, we do have a quorum. Also with us today is Florine Davidson, clerk to the commission, as well as Chris Moander, counsel to the commission from the AG's office. On today's agenda, what is on today's agenda? Oh, hold on. Agenda item number 2 will be agenda approval of the agenda. Commissioners, have you reviewed the agenda and do you have any changes to it?
Madam Chair, yes, I have had the opportunity to review the agenda, and no, I do not have any changes.
Is there a motion to adopt the agenda?
I so move.
I second that. Mr. Moander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Bloom?
Approved.
And Chair Sandoval?
Approved.
The motion is passed.
Thank you. Agenda item number 3 is approval of the January 4th through 15th, 2021 minutes and February 11th and 12th, 2021 minutes. Commissioners, do you have any, have you had time to review the minutes and do you have any changes to them?
Madam Chair, I have reviewed the January minutes. I have not seen the February. So I'd move to, I guess, approve the January minutes. And then I don't know if we need to do this separately, but I would move to table discussion of the February minutes until the next meeting.
Okay, I will second the motion to adopt the January 4th through 15th minutes. Mr. Moander, would you do a roll call vote on that, please?
Yes, Madam Chair. Commissioner Bloom?
Approved.
And Chair Sandoval?
Approved. And then,
motion passes.
Thank you. And then I will second the motion to table the approval of the February 11th and 12th minutes until the next meeting. Mr. Moander, do you, well, maybe before I confirm that, do you see any issues with adopting those minutes at the March 25th meeting?
No, Madam Chair, and I think in fact that is, I think you ordered that already at the end of the February meeting. So that would mean that this is already essentially set for March. And though the February minutes are the minutes from deliberation, so I think we're going to do all of the venting rulemaking wrap up at that March meeting. So I don't even think we need a vote at this meeting on that because it's already been set.
Okay. But since it was on the agenda, it might still be good to make a motion to discuss it at the March 25th meeting.
That's fine too. So it sounds like the motion was proposed and seconded, so I think we're prepared for a
Do you do
vote.
a roll call?
Yes, Commissioner Bloom
Approved.
and Madam Chair Sandoval.
Approved.
The motion carries.
All right. Next item on the agenda is case number 15855. It's a status conference in the application of Delaware Energy LLC to revoke the injection authority granted under SWD 1680 for the Alpha SWD number 1 well operated by Alpha SWD Operating Company out of Eddy County, New Mexico. Counselors, are you on?
Yes, good morning, Madam Chair, members of the commission. Michael Felderwert with Santa Fe Office of Holland and Hart, appearing on behalf of Delaware Energy LLC.
Good morning.
Good morning, Madam Chair and Commissioners. Dana Hardy with the Santa Fe Office of Hinkle Shaner on behalf of Alpha SWD Operating LLC.
You're coming in a little quiet for me. Can everybody else hear Ms. Hardy?
It was a little quiet as well, Madam Chair.
Okay, let me turn up my volume. My headset wasn't working.
When you got a little closer, it got better, actually.
You sound good now.
Okay, great, thank you.
Okay. All right, counselors, would you, starting with Mr. Felderwert, like to make any brief statements on behalf of your clients?
Madam Chair, members of the commission, this case has a tortuous history that started back in October of 2016. And as you know, resulted in a decision from the First Judicial District Court here in Santa Fe that resulted in the remand, or essentially the remanding the case back to the commission to address what is Alpha SWD's de novo appeal of the division order that revoked Alpha's injection authority. So we have a division order in place now that revoked Alpha's injection authority. They have filed a de novo appeal. That is where things got a little haywire with respect to the commission proceedings, resulting in the district court decision. But it is now back before the commission under Alpha's de novo appeal of the division order R14484-A. So since it's Ms. Hardy's client that has the de novo appeal, I'm going to punt to her because I'm not sure what they want to do and where things stand necessarily with the parties. I know there's been some discussions between the parties. Those have been going on for a long time. I'm not sure. I really don't have any information on whether they're productive or not. So I'm going to leave it to Ms. Hardy to at least give the commission an idea where she thinks it stands and what they want to do with their de novo appeal.
Okay, thank you, Mr. Felderwert. Ms. Hardy, would you like to address the commission?
Yes, Madam Chair. And I just wanted to briefly mention that I'm sure the commission is aware that this case has been continued numerous times. And the reason for those continuances has been that the parties were negotiating and attempting to reach a resolution. I am optimistic, well, maybe I shouldn't be optimistic, I don't know. I'm hopeful that they may still be able to reach a resolution. At this point, I think since the case has been remanded and is pending back before the commission, the status really would be that Alpha had filed a motion to dismiss Delaware's applications for a lack of standing. And that was filed with the commission in November of 2018. And that motion was never ruled on because the commission subsequently determined that the division had lacked jurisdiction, and then that resulted in the appeal to district court. So my thinking is that the best way to proceed may be for the commission to issue a ruling on that motion. And that would then allow the parties to determine, or allow Alpha rather, to determine how to proceed and whether they want to go forward with the de novo hearing. And
Ms.
whether they
Hardy?
can reach a resolution. Yes.
This is Chris Moander. Was there an actual hearing held on that motion? Or because what I'm trying to figure out is whether the parties will want or need a hearing on that motion, or if one was already done, approximately when that was. Because I think that issue predates obviously my involvement with the commission, but I think if I remember right, that may even predate the current chair. So I want to make sure that the parties get their proper hearing.
Right, and it predates me also, actually, with respect to this case. And I have reviewed the record. I think the parties discussed the motion, but I don't know that a hearing was actually held, and maybe Mr. Feldwart can answer that question.
Unfortunately, yes, because I guess I'm the only one that was around at the time this was occurring. If you look at the record, and in fact, I think the district court decision has a pretty good summary of what occurred, and would be helpful, I'm sure, for the commissioners, and perhaps their counsel to review. But essentially what happened is in October, before there was a change in administration, the prior commission had gotten together, looked at the issues, and Alpha wanted to pursue their standing motion. So they said they would have a hearing and have oral argument on the standing motion. And they wanted the parties to, at the same time at that hearing, to address the proper remedy for the defect that is undisputed with respect to Alpha's permit. So there was every anticipation way back in October of 2019, I guess it was, actually 2018, that there was going to be a hearing on the standing motion, and then the parties would also address the proper remedy to deal with the defect in the issuance of the Alpha permit. That hearing did not happen. And instead there was a change in administration, there was a change in course. The commission decided to issue a decision that they didn't have jurisdiction. That's what resulted in the decision to the district court, which reversed that. And now we're back to, I guess, where we would have been in October of 2018. So I think, there's two ways you can go. I think the district court opinion actually is very informative, at least from my perspective, on the issue of standing and what's not disputed here. But the commission could certainly take a look at the standing issue and then also address what remedy makes the most sense to deal with this defect in the issuance of Alpha's permit. Or simply uphold the division's order that was issued in 14484-A.
Okay. Thank you, Mr. Felder. I appreciate that quick rundown. It sounds like to me that at least, would the parties anticipate a motion hearing on this to be terribly long? I mean, I've looked at the ruling and some other things, but what I'm asking is, does either party feel strongly that a hearing would be beneficial? Because I'm inclined to think it would be, but I also don't want to foist that on anybody or have the commission foist it on anybody.
Well, I might just say that, since I think this has such a long history, I don't think this commission has that history other than, I guess, reading through the district court opinion. And in order to make an informed decision that might be helpful, I am open to other ideas. But whatever the path forward is, we need to make sure that the commission has all of the information that's necessary in order to make an informed decision.
And on behalf of Alpha, Madam Chair, I think we would be okay either having a hearing on the motion or not, but whatever would be most helpful for the commission would be fine.
I mean, my inclination would be to have a motion hearing.
I think that's a good idea, Madam Chair. That way we can get everything laid out. Any new information can be added by the parties and we can at least get the record tidied up and get a supported finding from the commission.
Commissioner Bloom, do you have any thoughts, or does that make sense to you?
This makes sense to me. I'd be supportive of that. Thank you.
Okay. So I guess I'm not sure what the process would be. Probably work with Commission Clerk Davidson to get on the calendar.
Madam Chair, the only thing I can add, and I think Ms. Hardy would agree with me on this, I don't think the motion hearing would take very long. I think you're looking at an hour or two at the most, I would think. I mean, depending upon your questions, but I can't see our oral argument being all that long.
And Madam Chair, I do agree.
Okay, that's good to know. All right, well then on this matter, the parties will work with probably both Mr. Murander and Ms. Davidson to make sure we can get this scheduled on the docket in the next coming months.
Thank you, Madam Chair.
Mr. Murander,
Thank
do
you,
we
ma'am.
need any sort of formal motion on that, or?
We're scheduling another hearing. So I don't think that's not yet commission action. So I think we're okay. We just got to get it scheduled and then the commission can vote on the particulars.
Okay. All right, great. Thank you, Mr. Feldowert and Ms. Hardy.
Thank you.
Thank you.
Thank you.
All right, let's move on to agenda item number 5, which is case number 21529. This is also a status conference on the application of Wild Earth Guardians for amendments to the release spill rule 1915-29-6 and 1915-29-8. Mr. Timmons, are you on? I see you. Can we hear you?
This is Daniel Timmons on behalf of Wild Earth Guardians.
Okay. Mr. Ames, I just want to make sure, are you on and can we hear you?
Good morning, Ms. Sandoval.
Good morning. And then I think Mr. Feldowert, you will continue to be on
Yes,
this
ma'am.
matter as well.
Yes, ma'am. On behalf of, I should say, Michael Feldowert with Santa Fe Office of Holland and Hart on behalf of the New Mexico Oil and Gas Association.
Okay, great. Well, we have everybody then, so let's go ahead and proceed on this matter. I believe today we want to discuss the schedule and some of the logistics. We had discussed this back in November, I think on the November 4th hearing, but there have, I believe, been some changes potentially to the timing and process the commission needs to consider. And I believe Mr. Moander yesterday circulated a draft scheduling order to the parties. I'm sorry, procedural order. Mr. Timmons, we can, since you are representing Wild Earth Guardians and submitted the application, do you have any statements on the procedural order or the process for the commission?
Chair Sandoval, yes, we do have some specific comments. I mean, there are a few sort of blank dates to be filled in on that proposed procedural order that I've seen. So, I mean, we certainly have thoughts on those and a couple comments that we would like to make with respect to the public comment at the hearing. I'm not sure if this is the time to sort of get into the the details of that? Okay.
Yeah, I think
Um,
now would be great. Let's, I'd like to hear from you and then the other parties, and then the commissioners can take that information under advisement and figure out a path forward.
Okay. First of all, I think overall, I mean, just for context, I have checked and it does appear that the New Mexico register notice did get put out on the 23rd. So I think we are on track to have a full 30 days public notice prior to the April 1st hearing date. So I don't see an issue there. The primary change, I think, was that notice went out later than anticipated in November. And so in order to provide the 60 days of public comment that the commission was in favor of back in November, discussed with Mr. Moander extending the public comment period past the hearing date to, I believe, April 26th, which would allow for that full 60 days of public comment. Guardians is in support of that. We think that that would provide a good opportunity for the public in particular to provide informed comments after the hearing and for the commission to make an informed decision. With respect to sort of the blank spaces in the proposed notice, motion hearing prior to rulemaking hearing, we would request that any motions be filed essentially as soon as possible. I think that perhaps a March, well, I guess it's sort of, I should maybe go to the technical testimony first before we talk about that date. We would suggest a technical testimony filing, so that would be the technical testimony date. I would say March 17th, I believe, would be appropriate, which would provide 2 weeks for council to review the other party's testimony and prepare for the hearing itself. That would be our recommendation. The motion hearing, I think it would be appropriate for dispositive motions to be filed by March 10th would be our recommendation. And responses by, what was I lost my notes here, March 24th. And then, essentially any hearing, this is a little tricky just because of the tight time frame. I guess our general inclination would be to have any dispositive motions heard as soon as possible, just in order to avoid having to prepare for the hearing while dealing with motions, and in particular, preparing for the hearing that might not go forward if there is a dispositive motion. I don't anticipate one. Perhaps the other parties have thoughts on that. Certainly Guardians is not intending to dismiss this hearing. So maybe I'll just sort of punt on that one for now. I think the other issue that we have identified is in part 6, the public comment at hearing. Kind of 2 issues there. One in part A1 or AI, it appears that the language with the sole exception of the first day of the hearing, and then starting April 2nd, 2021, it appears that there is no public comment contemplated for the first day of the hearing, April 1st, which I believe does not comport with the regulations at 1915-312, that 1915-312A2F, which indicates that if the hearing continues for more than 1 day, the commission shall provide an opportunity each day for public comment. So I believe that public comment by the rules should be, or an opportunity for public comment at least should be provided each day at the hearing. I understand that that's sometimes can seem a little unwieldy, but that's my reading of the rules, so I think we should comply with those rules. The other issue is in that same section, it says the public may make comment at the hearing at a time and place to be identified. It seems appropriate that this would be the time and place to identify where those comments could be made in this procedural order. I think that it's the public is served by having specific times in particular of the day, or a time or two in which that public comment will be made available, so that they can schedule accordingly. And so, I mean, I would propose that there be an opportunity for public comment at the start and at the close of each day, or maybe not at the start of the very first day, but that, you know, early in that first day, say 9:30 a.m. and then 4 o'clock on each day, that sort of be opened up, or 4:30 even, be opened up for public comment. Based on the level of public engagement that we saw at the produced water hearing, I would anticipate significant public interest in this rulemaking as well. So I think we want to provide ample opportunity for public comment here. I believe that those are my only initial comments, and I will now turn it over to the other council.
Thank you.
And just
Oh, go
Just a
ahead, Mr.
comment
Reiner.
from me, Madam Chair. So I took a look at the order and I agree with Mr. Timmons. So I went ahead and removed with the sole exception language and then edited to get the dates clarified. And was it 6A I?
Okay. All right. Yeah. And after we hear from the parties, we can also, I think there needs to be some discussion probably from the commissioners on what that structure is. But I don't want to do that until we've heard all the parties. I think at this point, at least, we have some lessons learned from all of the hearings, some things that worked well, some things that haven't, but at least we have some experiences at this point to go off of. This is not the first rodeo. All right, Mr. Ames, do you have any
Yes, Madam
statements?
Chair. I do. Thank you. Just a couple of points I'd like to make. First, with respect to the date for filing the pre-hearing statements, Mr. Timmons suggested March 17th. That's the date we're planning on filing in any event per the rule. And so we have no objection to that. As for motion practice, at the current time, we're not anticipating filing any motions, but March 10th seems a little short. As you noted, this is not our first rodeo. We had a pretty significant hearing recently, working within tight timeframes in that context. And in the context of that rule, the venting and flaring rule, we filed motions on the day that the pre-hearing statements were due, had responses shortly thereafter, and a hearing before the evidentiary proceeding even started. So I don't see any reason to deviate from that tried and true practice. There's nothing significantly more complex here than existed in that rule that warrants some earlier filing date. My last point is really a point of concern. I am concerned about the 60-day public comment period extending beyond the evidentiary hearing itself. When the hearing ends, my understanding is normally the record would close. But in this instance, the commission appears intent on accepting public comment after the hearing has ended, after the parties have presented their cases. My presumption is that the commission would want to consider that public comment in the context of its deliberations. But that would present a problem for the parties and potentially an appealable point, because the parties would not have an opportunity to address that public comment in any meaningful way. There's a couple options here, some more palatable than others. The one that I would suggest, given that the commission has already published public notice extending the public comment period until after the hearing, would be to allow the parties, if they deem some public comment worthy of response, to request an opportunity to reopen the proceeding to address that public comment before the commission makes its final decision. That's all. Thank you.
I just have a quick question. So you said, let's see, request an opportunity to reopen. Wouldn't it inherently still be open though?
The parties will, I'm not entirely clear, Madam Chair. The parties will conclude their cases presumably on no later than April 9th, hopefully before that, but they'll conclude their cases. They'll have presented their testimony, been subject to cross, presented rebuttal, their cases will be done. Then the commission would be accepting public comment. Presumably the commission is accepting that comment because it wants to consider it. And Mr. Timmons, in fact, indicated that he fully expects the commission to consider public comment after the hearing has ended. It's in this, we just want to be sure that the parties have the ability to address any public comment that comes in after the hearing is closed, which would mean that the record would have to be reopened for the parties to present additional testimony if necessary.
Okay.
And from looking at the rules, just to clarify, I think there's some sections that address Mr. Ames' concerns on it's section 3.12 AG. It contemplates that the commission can keep the record open for purposes of written submittals, including arguments, statement of reasons supporting a decision by the commission. There's a variety of them, but if you parties and the commission will look at 3.14 sub B, the official record does need to contain comments and material received. So I think the commission's in a position where if it wishes to leave the record open, it doesn't actually need to close it until, in this instance, two events occur: the closing of the comment period and then a responsive, any necessary or desired responsive pleading by the parties. So I think that's achievable through the rules.
Madam Chair, if I may respond. With all due respect to Mr. Moender's comment, OCD does not agree that the provisions cited allow the parties to submit additional evidence. The provision cited in section 12 concerns the submittal of written documents based on evidence already in the record. If comments are accepted after the hearing has concluded, the parties would not have the ability to submit additional evidence, in my view, because any such evidence would have to be subject to examination by the other parties, and that would not be possible unless a hearing was held.
So just to clarify this a bit, is it Mr. Ames, am I getting this right that the concern here would be that a written comment introducing evidence not previously discussed at the actual substantive rule hearing, how would the commission proceed with examining a witness that provides written comment? I mean, how would that work? Like, how would that witness be compelled for examination with I'm assuming you were just talking about general comment and not technical comment, which would have necessitated, of course, the pre-hearing statement well in advance of the rulemaking hearing. I'm trying to figure out how that would work.
Madam Chair, OCD is not suggesting that a public commenter would be compelled to appear and testify. OCD is suggesting that it may want an opportunity to present its own evidence in response to a public comment. As well as the other parties may want to. It's hard to know what commenters may submit after the record is closed, after the hearing is over, I should say. And we want to be sure that that evidence is not submitted into the record after the parties have concluded their cases, that the commission, having read those comments, could then rely on in making its decision without the parties having an opportunity to counter it if necessary. All I'm asking for is the opportunity to request that the hearing be reopened to allow the parties to present evidence if necessary to address public comment. I'm not sure it'll be necessary, but I'm concerned that absent the matter being addressed in the procedural order, we may be left with a potential problem with the process.
Okay, Commissioner Bloom, do you have any questions for Mr. Ames before we go to Mr. Felderwert? I mean, there will be more opportunities if you have questions later too.
Yes, yes. Thank you, Madam Chair. I think I would like to hear from Mr. Felderwert first, and then I do have some concerns about leaving the record open after we have had the hearing. So, but please, Madam Chair, I'll turn that back to you.
Okay, thank you. Mr. Felderwert, do you have any comments on the draft procedural order or any of the comments your counterparts have made?
I believe you're muted,
I
Mr.
can't
Felderwert.
hear you, yeah.
Now can you hear me?
Yes.
Sorry about that. Thank you. On the issue Mr. Ames raised, I do agree with him on that. There's a couple things I can offer. One is the usual practice is that you have public comment before the hearing. And in fact, that's what the rules contemplate when you read them, is that public comment is to exist no later than the date of the scheduled hearing, unless the commission chairman or the commission extends the time. So the normal course of event is to have a public comment before the hearing. And then if there's something that comes up and the commission decides additional public comment is warranted, they determine it at that time. The other thing is, as others have pointed out, it is part of the record. It is part of the record. It's not necessarily evidence, but it certainly is part of the record and will form, at times, has helped formulate how the parties to the case are going to present their case. So Mr. Ames is correct, in that we do raise an issue when we automatically allow public comment to extend, in this case, well beyond the anticipated hearing dates, because it raises the potential issue that something is said, something is presented that shouldn't be presented because it's technical in nature, which can happen, right? It should be excluded. Or in other words, it's not a true comment. Or it brings forth some issues that one or more of the parties feel like they should address, given the nature of the comments. So I'm not sure why we would automatically, at this point in time, extend the public comment period well beyond the hearing date. As Mr. Timmons pointed out, there is going to be 30 days available for public comment before the hearing. This is not an extensive rulemaking. I don't know what Mr. Timmons intends to do, but if you look at the language that they seek to add to the rule, it's not that there's not a whole lot there. It's very simple. They want to make releases prohibited. It's nothing more than that. So I don't see this being an extensive hearing. I don't see this one generating a lot of public comment that would require this unusual procedure. And I am concerned about having this period extend well beyond the hearing date. If the commission feels like it wants to have a 60-day period, there is no reason then not to have a hearing in May. Just wait till May and you can have your 60-day period. But I don't see why you need that here. And I think having the 30-day period, starting the hearing, and then having an additional 30 days after the hearing creates some problems that are unwarranted here. So I have to agree with Mr. Ames. I think this is unusual. I think it raises a lot of issues, and I just don't see in this type of rulemaking that it's warranted. The second concern I have is with the application itself. And this, I guess, goes again to what Mr. Timmons intends to do at the hearing. The commission's rules, and it's 1915.3.9 B7, requires an applicant at the time that they file the application for rulemaking to provide citation to the technical information forming the basis for the application. That identical requirement exists in the State Rules Act, Section 14.4-5.2. This requirement has existed. It exists now and exists for good reason, because it allows the commission, it allows the general public, it allows the affected parties to understand the technical information that an applicant feels supports the rulemaking, and to prepare for the hearing. Now, the Wild Earth Guardians in this application have brought forth a very finite and limited amendment to the rule. But they have done so with an application that has some very disturbing factual allegations that I guess they consider purportedly support this rule. And I'm talking, or they're limited change. And I'm talking about statements like, it's well-established radioactivity of oil and gas waste. Well-established radioactivity of oil and gas waste. That a vast majority of toxic chemicals found in oil and gas related releases are not covered by the Commission's cleanup rules. Another statement in here, approximately 700,000 gallons of toxic produced water has been lost to the environment. Another statement, 13.3 million gallons of toxic, potentially radioactive oil and gas waste remaining in the soils of New Mexico. Now, those types of statements, it seems to me, go well beyond the language that they have brought forth here. But my point is if they intend to present this as part of their case, if this is what they're relying upon to support their rule change, then they have an obligation at the time they file the application to cite to technical evidence that supports that. And I'm talking about specific citations to technical evidence that would support, for example, an allegation that it's well-established radioactivity of oil and gas waste, that there's 13.3 million gallons of toxic, potentially radioactive oil and gas waste remaining in the soils of New Mexico. They have an obligation to support those allegations with technical information when they file the application, so that we can look at it, you can look at it, the public can look at it, and adequately prepare for a hearing. And they haven't done that here. Now, if they don't intend to pursue that at the hearing, and that this is just an effort for them to raise money and make it look bad, but if they don't intend to pursue it at the hearing, it's not an issue. But if they intend to pursue these types of allegations at the hearing, that they had an obligation at the time they file their application to cite to specific technical evidence that supports those allegations, so that the public and the affected parties can adequately prepare for a hearing. You don't wait until shortly before the hearing with your pre-hearing statement and say, aha, here's all our evidence. Here's our technical information that we rely upon. No, the rule says the applicant cites to that at the time they file their application, which is not done here. So that's what the rules require, and that requirement has not been met here. So I think there's a problem. But again, if Mr. Timmons and his group doesn't intend to pursue those allegations, fine, it's not an issue. But if they do, then they get a defect in their application. So I have a couple concerns. One, the public comment period. And two, this matter going forward, if indeed Mr. Timmons intends to pursue those types of allegations in this kind of hearing, because it changes the whole nature of the hearing. And they have not met the procedural requirements bringing those types of issues to the commission.
Mr. Feldwart, it's Mr. Melander again.
Yep.
So are you requesting the commission take sua sponte action vis-a-vis WEG's application? And I ask that because this sounds like fertile ground to plow with a motion to dismiss. So I'm trying to figure out what avenue Namoga is looking at to seek a remedy to its concerns.
Well, I think that depends on what Mr. Timmons and his group intends to do here. If they intend to pursue these types of allegations, then yes, this would be, as you say, fertile ground for a motion. I don't think it's very complicated because the rule and the statute is very clear.
Can we, so it may be best at this point to let Mr. Timmons address some of those questions, and then the commissioners can circle back around and ask questions to all three counselors as is needed. Mr. Timmons, do you want to address any of the items that were brought up by Mr. Ames or Mr. Feldwart?
Yes, Chair Sandoval. First, with respect to the timing, I mean, I think that the Mr. Ames concern, I'm not sure that I fully share it, but I don't necessarily object to allowing the parties to request to reopen the hearing. You know, I don't know that necessarily has to be through an in-person hearing, or if that could be done in a written format. But if Mr. Ames is, you know, really thinks that coming back before the commission in a public manner is required to meet that, we don't object to that requirement. With respect to Mr. Feldwart's concerns regarding our citation to technical information, in our application, we did cite to essentially the spills database in the OCC. We did not cite to all technical information that's underlying this with respect to concerns about why oil spills are a problem, why spills of produced water are a problem. I would be curious if Mr. Ames agrees with that, and when the division puts forth a rule, if they provide all technical information that supports the rule as part of the application, because that is not my understanding that that's the process. I will note that the rulemaking notice cites to a hydraulic fracturing report from EPA that does include significant information regarding radioactivity and toxicity with respect to oil and gas waste. I need to double check that public notice that went out. And now I'm not seeing it. Where did that go? Here's the New Mexico Register. Okay.
And that's, I believe that study is cited in the notice. I'm looking at it right now.
Yeah, the public notice does in fact cite the hydraulic fracturing report from EPA. So I mean, I guess there's a question with respect, I guess potentially a question. The public notice did not match up with what was in the application itself. If that's a concern of Mr. Felderwert's, I would appreciate understanding that distinction there. If it's an application problem or a public notice problem, because I'm unclear there. It does appear that the public notice did include significant information with respect to the toxicity issue. Of course, it does not include all the information, all the technical information that will be presented. I don't read the rules as requiring that, and that's why the technical testimony is provided. I don't believe that we're required to put on our entire case as part of the application. I don't believe that's what division's practice regularly is. Thank you.
Madam
you.
Chair?
Mr. Timmons, Mr. Ames.
Yes, Madam Chair. Mr. Timmons suggested that, can you hold on for 1 second? I apologize. There's someone vacuuming outside the room. 1 second.
That's better than the UPS man at my house.
My coworker's on break from 5th grade. He's making a lot of noise in the background. I'll have you all on mute as well. He goes back into class in 1 minute. So.
Ooh.
Thank you. I apologize for the delay. Mr. Timmons asked what OCD's position is on this. As a matter of the rule, OCD agrees that technical information needs to be provided with the application. And the rule also says it needs to be provided with a public notice. In the last rulemaking, OCD did provide all its technical information with its petition, and it was all published in the notice as well. We had about more than 60 references supporting our draft rules. There are a couple factual claims raised in the petition that concern us, but we weren't going to make a big deal about it. But I think that it's important to note that the EPA report that's referenced doesn't, I don't believe, contain New Mexico specific information. Now, one of the factual claims that's raised in the petition concerns how much produced water and oil field waste is quote unquote lost in the environment. And I don't believe there's anything in the EPA report on hydraulic fracturing that's going to address that concern. I would suggest one solution, which to the situation, to this problem, if the commission perceives one, which is that wildlife guardians could agree not to present technical testimony regarding those factual claims for which it does not have for which it did not disclose the technical information. From our perspective, OCD doesn't oppose Wild Earth Guardian's proposal. We will be proposing some changes of our own to ensure that we can effectively and efficiently implement the proposed change. We think that the petition can go forward without those factual allegations. We believe that there is sufficient basis in the references to the OCD's website and database regarding the number of spills, and sufficient policy arguments to be made for which technical information isn't necessary. So I would suggest to Mr. Timmons that Wild Earth Guardians could solve the problem by agreeing not to present testimony on those factual claims for which there is no technical information disclosed in its petition or published in the notice.
All right, Mr. Feldewart, you get one more shot at this since everybody else got 2 times.
Okay. Mr. Timmons aptly noted that apparently the public notice does not match up with what was filed with the application, which I think itself is a potential problem. And certainly what the Wild Earth Guardians filed with their application, and you can look at it yourself, was nothing more than a high-level generic citation to the entire database of the division spill records. No, nothing specific, no records identified, no indication of what they're relying upon within those records for their allegations that they put forth. Same thing with the EPA report, and it sounds like they did it for good reason because there's nothing in there that supports what they put forth. But all that being said, I agree with Mr. Ames. That's why I said I'm not sure we have to file a motion. My understanding is NMOGA is not intending to oppose this effort. I think there's some language tweaks that can be made to accommodate the effort that's being done. That's why I don't think this is going to be a big deal and a big hearing. And I agree with Mr. Ames. I don't see that we need to pursue all these other allegations to accomplish the limited amendment that the Wild Earth Guardian seeks to pursue here. My point being, though, that if they intend to pursue all these allegations, then there is a defect here that needs to be addressed. Because this application is not in a position to allow it to go forward to address all these factual allegations that they have put in this application. So I don't know at this point whether we need to file a motion. I would hope not. And if Mr. Timmons is not going to pursue these allegations with his witnesses, because I don't think they need to, then we don't need to deal with the defect and then prepare for a more extensive hearing.
All right, thank you. Commissioner Bloom, do you have questions for the counselors?
Madam Chair, thank you. Yes, first, and well, do we want to stick with the issue of the application and technical citations, or should we go back to the comment period?
So in my mind, we have a handful of things we need to determine. We need to the motion dates. We need to probably discuss some of this technical issue. We need to talk about what the structure of public comment looks like. Potentially the written comments and what that looks like, keeping the record open. So, I would say at this point, I would ask any questions of the counselors that you want on any of the topics, and then we can, both of us discuss sort of where we want to go after that. And if you'd like me to go first, I'm happy to do that.
I'll stick to the issues around the application, and I guess Mr. Felderwertz and Mr. Ames's views that technical citations would be necessary if some of the claims were to be argued during the hearing. I guess I'd like to know from you, Mr. Timmons, if you intend to do that. And I mean, ultimately, it sounds like Mr. Felderwertz for his clients would file a motion to take that issue on, and we'd simply hear it. And I'm fine doing that. So why don't we stick to this, and then I want to talk about public comment.
Thank you, Commissioner. Yes, Wild Earth Guardians does intend to pursue the technical evidence. I think based on essentially that EPA report, as well as the OCD spills database, I believe provides sufficient information to inform the commission regarding the scale of the problem of spills in the state. I think that there's sort of the numbers that Mr. Felderwertz describes, those all come out of the spills database. I don't believe that the spills database is citable in a more specific manner in terms of the aggregation of those numbers. I mean, so I do believe that that's a appropriate citation there. I am now a little bit concerned about the lack of citation to the database in the public notice, given the issue that Mr. Felderwertz has raised here. And so I don't want to be in a position where we are not able to present information from OCD's spills database at the hearing. I think that would be very limiting. And so if that is a concern of the Commissioner, Mr. Felderwertz, I think that perhaps we do need to I hate to say refile. I mean, we filed this back in, I don't even remember, back in the fall, and we've pushed it out probably 6 months now. So I'm a little concerned about pushing it out even further. I am wondering if it's possible for us to refile and get on the May calendar. If we were to refile something and get it publicly noticed. And I would certainly try to discuss with Mr. Feldwert his concerns in more detail to resolve that. It does sound like perhaps we are sort of more in procedural territory here. I mean, it's a little concerning to me, given Mr. Feldwert saying that his clients are not going to oppose this, but then raising all these procedural hoops to jump through to try to actually get this on the books. It feels like opposing it. So I'm just trying to figure out how we navigate this, since everyone says that they don't actually oppose banning oil spills in New Mexico.
Thank you, Mr. Timmons. So it sounds like you have some thinking to do there, and again, I think we heard concerns about having technical citations to issues with hydraulic fracturing in New Mexico, and also with respect to radioactivity. If we can make that part of your case, it appears to me that citing the technical references in the application would be appropriate. I don't know if it's about a refile or I don't believe there's an amendment, so I imagine we're looking at a refile here. If that's something you want to do, I don't know that I have a dog in that fight. I do like to see I guess a case come before us that is not encumbered by these sorts of issues. And Madam Chair, I'll turn this back to you, and maybe we finish this part of the conversation, and if necessary, we can talk about public comment later.
Okay, thank you, Commissioner Bloom. And maybe this is a question for Mr. Molander. What exactly is the issue between the legal notice and what was filed? Like, where did that,
So
what happened?
here's where, here I will acknowledge here that there is an inconsistency that I did not, I don't know why I did not catch that. Technical information in the application originally just, it cites to a database inside the OCD, and I'm not clear why I ended up with just citing the EPA study. That may be an issue of me misunderstanding what qualifies as technical. So there is a distinction there, their difference. And if the parties do have some concern, and now we've got all three parties. So just so we're clear on this, I did circulate this for any additional input. So having this raised at this point is a little frustrating for me as I'm trying to get this accomplished for the commission. But I think what this would essentially mean is the technical information section in the notice as it stands now would have a paragraph added that would be identical, well, substantially similar to the one in the original proposed notice. And that would change it brief. That would be the only change that I'm aware of, other than comment period that could be accomplished. Now, if there's gonna be a reapplication here, the other issue is gonna be New Mexico Register publication. I'm looking for the schedule right now. And that always impacts timing because they only work on a 2-week schedule. So I would need to look into that.
Yeah, if this was refiled, I guess I'm wondering what, that would be my second question. Like, if it was refiled, what would that schedule potentially look like? Because I know there are these set dates and sort of hoops to go through.
All right, the first issue that I think this can be done on why is this not Yeah, 1 second, please, Madam Chair. Let me find that.
Madam Chair, as an initial point, I believe the commission cannot consider a petition until a certain number of days after it's filed. So that's the first step. So it'll have to be a hearing sometime after the petition's filed. It's not a lengthy period, but it's about, I'm thinking like a week or something like that. And then when the commission makes its decision to hold a hearing, then the notice needs to get published in the register, but the register is discontinuous. It's on a 2-week submission schedule. So the hearing would have to be set 30 days out from the date of publication. So that could be roughly 45 days after the commission decides to have a hearing. So you're looking at about a 2-month time lag between when the petition's filed and when it can be heard.
Okay.
And that doesn't take into account if you want to create a longer public comment period,
Right.
longer than the 30 days.
3.8 sub C, it's, you've got, the petition has to be sort of outstanding at least 15 days, but cannot be outstanding no later than within 60 days of the filing. So within approximately 2 weeks, the process could begin upon filing of a petition, like the actual commission activity.
But we would also, I'm just thinking about procedurally here, like let's just assume it was filed tomorrow, making things up right now. But the commission wouldn't meet again scheduled until March 25th. So the commission would likely have to schedule a special meeting in order to consider this. And I don't know offhand what the notice requirements for that are. I feel like it's like 20 days, but maybe if it's an emergency meeting or a special meeting or there's a shorter time frame, I very much, I think I'm have the two pieces here. I very much agree with Commissioner Bloom. I want everything procedurally to be clean so that the commission can actually take into account either the policy or the legal or the technical or whatever pieces of information at the hearing, and we're not stuck on the procedural stuff. But the other side of me does understand that this was scheduled for April originally because of the waste rule hearing and of session, and pushing it back anymore is not my ideal scenario. So I would like to have all the information so that can sort of balance those two priorities.
Madam
I
Chair.
also sort of wonder if the appropriate place to discuss these technical problems is in a dispositive motion or a motion, and not in this venue. That's, I'm not necessarily asking for a response here. That's more me, like, just sort of trying to figure out where to go here.
And Madam Chair, I'm pulling up a slew of PDFs. I'm looking for some information to give more guidance, so it'll take me just a minute.
Okay.
Madam Chair.
Yes.
While Mr. Miranda does that, if there is a refiling, that could potentially give us more time to have the public comment done the 60 days completely before the hearing. And I know that we're all interested in having robust public comment, or at least treating public comment with the seriousness that it deserves. I have some concerns about public comment coming in along the lines of what Mr. Ames discussed after the hearing, before deliberations. I'm not sure that creates the cleanest path for the commission. I don't know if a 30-day public comment is technically allowable if we go to that, or we push back and we get all 60 days done before. I think that would be cleanest.
I believe the requirement, it has to have a 30-day, I think 30 days a minimum. And then extending it from there is by choice.
Yeah. And I'm sorry, and Mr. Timmons, are you still with us? Look, can you hear us? Mr. Timmons, are you muted? I saw you have a little, I think, a distress signal up there on the corner of the box.
Yeah, there's like a little caution, looks like a symbol up there. Maybe internet issues.
Yeah, I'm thinking internet issues. He went down suddenly. If we might want to take a 5-minute break and see if Mr. Timmons comes back, give Mr. Moander a moment to find his material.
That's a good idea. Why don't we take a 5-minute break? It's 10:20 right now. Come back at 10:25.
All right. Thank you, Madam Chair.
Mr. Timmons, were you able to rejoin us?
Yes, Madam Chair, my apologies.
Okay. Mr. Moander, are you there?
I am.
All right. Where are we at with maybe timing?
Madam Chair and Mr. Ames, are you back?
Oh, good point.
I am, Commissioner. Thank you.
Okay.
Do we have Mr. Timmons?
Yes.
Yes.
Okay.
Madam Chair, members of the commission, I'm going to interject here if I might. I've been thinking about this while this conversation was going on, and I had a chance, I appreciate the break, I had a chance to visit with my client. I think there's a real possibility here that if the parties on the phone here, the division, NAMOGA, and Wild Earth Guardians, through Mr. Timmons, had a chance to sit down and talk about the language, that there's a decent chance the parties are going to be able to agree on language and avoid this whole, all of these issues that have arisen and exist. So I offer that as a method of trying to move this forward, because I do think there hasn't been any collaboration or an effort. And I think, I'd like to hear Mr. Timmons, Mr. Ames's view, but I just got to believe, given the limited, the effort that's being made here is finite. And I would suspect that if the parties can sit down and talk, that there might be some consensus on the language.
Madam Chair, OCD concurs. As I said earlier, OCD doesn't oppose the petition. We just have a few changes we would propose to make the change workable. But we think a consensus proposal is possible.
And just to clarify, which language are the parties referring to?
Mr. Moander, I am referring to Wild Earth Guardian's proposal to make major and minor releases a violation of the rules.
Thank you, Mr. Ames. I want to make sure whether we were talking about procedural orders or what, but thank you.
Talking about substance, Mr. Moander, thank you.
Mr. Timmons, do you have any comment?
I'm happy to hear that. I would certainly would like to sit down with Mr. Ames and Mr. Felderwert and discuss this. I don't believe I'm in a position to delay either proceeding with this proposal or refiling a new proposal until that happens. Just given the delay that we've seen to this point, and sort of given the procedural time delay before we would be able to get to a hearing, it seems that if I were to refile a new application for a third time, there would be ample time for us to discuss the substantive language prior to, filing pre-hearing statements and suggested amendments, to where we could potentially all file the same suggested amendments or have a joint filing with respect to that language. So I'm certainly, me and my client are certainly open to having those discussions. And I think that had we not been in the position with the session and the methane hearings, I think that probably those discussions would have occurred by now. So I say in general, I appreciate that sentiment and look forward to those discussions.
Would the parties be able to discuss this today?
Well, I'm sure we could start to discuss it today. From experience, when you have three parties and three counsel and three parties, it can take time to reach agreement. But we certainly can start a discussion, yes.
So maybe just a clarifying question, Mr. Timmons, did you mean that it might be, I guess, was I hearing you correctly, and that it might actually be beneficial for the parties, all of them, to refile and have that opportunity for that discussion? Is that sort of what you were saying?
Well, I mean, I was more saying that given the sort of procedural issues that have been identified here today, I don't want those procedural issues to become the focus of a hearing or a potential challenge to a rule, even though I am also assured that the proposal is not fully opposed. So I want us to be able to focus on the substance of what we're proposing here. I think that I was not expecting this to be this type of hearing, and so I'm feeling a little out over my skis because I don't have my client here with me. And that said, I think given the procedural challenges here, I think it makes sense for us to plan to refile. And again, even just, I think, the public notice issue that both Mr. Felderwart has raised and that I've identified in just the list, the inconsistency between what we filed and what is in the public notice. I don't think that should ultimately be a major issue, but I don't want that to sort of take the focus off of what we're actually trying to do here. So I am going to propose that I guess the commission take no action on this here today, and that myself and Mr. Felderwart, Mr. Ames, and Mr. Molander have a conversation as soon as possible in order to and I would anticipate that if I would say if we are not in agreement on language, I mean, Wild Earth Guardians will file a new proposal, within a matter of days, and try to get this back on the calendar as soon as possible.
Okay.
Madam Chair, we appreciate Mr. Timmons' perspective on this. It sounds like the right course. One suggestion I would make is that the commission would need to vacate the hearing scheduled for April 1st in order for us to proceed on that course of action.
And that is correct. Let me get a citation. A few things that I do want to get addressed here is first of all, I apologize to everybody. Not very often we get private party rulemaking, so I do accept some culpability on some of this, but just for the sake of clarifying the next steps, So I mentioned earlier the 15 to 60 day window in which the commission needs to act. 3 special meetings can be generally convened with it's 72-hour notice or 3-day notice. That can be done fairly quickly, and once the application is submitted, that could be dealt with well in advance of a 3-day notice period, which I would strongly recommend. The publication schedule, it's going to depend with the register, is going to depend on how quickly the commission moves to get the special meeting set in light of the 15 to 60 day window. Next publication date for the submittal deadline is March 11th, which I don't think the commission could make, but the March 25th, I see no reason why it wouldn't. That would get a publication day of April 6th, and setting aside whether it's 30 or 60 day comment period, that could get a hearing set fairly quickly in May. It's achievable. It is doable. Something that I would be remiss if I didn't bring up, just for the parties' consideration as well as the commission. I did talk with Dr. Engler to get his schedule in case something like this pops up. He would probably struggle to meet in the first week of May, maybe even the second week, but I do think it is that could be managed. So that's what we're looking at in terms of timelines. When it comes to vacating the hearing or the hearing, there are provisions in the rulemaking for that. I have got too many PDFs up right now. It's getting to a point where like I can't find anything because I've got too much up. So I can pull that up, but if there is the commission votes to vacate those dates, I know that is doable within the rule. I just need to find the here it is, 3.13 sub D. Motion approved at a meeting is required. There'll be a notice of termination of this specific rulemaking through the register. And then there's a prohibition in here just for the sake of thoroughness. The commission, if it doesn't act on 2 years after the publication of notice of rulemaking, it'll be terminated. So the commission would want to act on that. I think that's not a concern here, but it's prudent to just know there's essentially a statute of limitation. But yeah, I would craft the notice, as is my practice. I like to circulate among the parties for review and comment, and then get that submitted as soon as possible to the register. So we'd be looking at, well, today there's a submission date. So I could move as fast as humanly possible on that and probably get that in. But that's what we're looking at.
Okay. Thank you, Mr. Melander. So it sounds like we need to take a vote on vacating the hearing dates in April.
That is correct, Madam Chair. And basically, at this point, I think what the commission could do, because the commission was going to need to vote on some new deadlines today anyway, is the commission could vote to vacate its vote from November 4th, the November 4th meeting, and that would subsequently vacate the April dates and all surrounding deadlines.
Is there a motion to vacate the commission's vote from November 4th regarding the Wild Earth Guardian proposal in case number 21529?
It's on mute, sorry. Yes, Madam Chair, I so move.
I second. Mr. Melander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Bloom.
Yes.
And Madam Chair.
Yes. All right.
All right.
That motion passes unanimously. I would just say, I think once we see the petition come through, I would encourage we try to set a special meeting in order to consider that so that the deadlines don't get pushed out too far.
And Madam Chair, I would like to ask the parties, because of what's gone on thus far, I want to make sure this goes smoothly. Please keep me in the loop on negotiations and such, so that way I can guide the commission. It is a priority of mine to get this moving efficiently, quickly, and properly. So the more info I've got, usually the better. And I think it also will be helpful if the scope gets narrowed, the rule change, that will also be beneficial and I think worth consideration in terms of comment periods as well. Will the parties agree to work with me on this?
Absolutely. Absolutely. We intend to reach out to, I apologize, Madam Chair, Mr. Melander, yes, OCD intends to work with you to ensure a smooth process going forward, and we intend to reach out to Mr. Timmons very soon to initiate discussions.
And I echo that, Mr. Melander.
I appreciate that from
Yes.
everybody.
All right, do we have any other matters to discuss in this case? It sounds like we have covered it. All right. Let's move on to agenda item number 6, update on pending litigation. Mr. Melander, do you have an update for the commission?
Yes, there was a Novo Oil, and if Madam Chair, if you want me to get case numbers for this, I realize I haven't been doing that recently. I can do that. There was the Novo Oil District Court appeal was ultimately resolved, and we're not anticipating any appellate issues with it outside the district court. And then there's the marker appeal. I filed a responsive pleading, and as did OCD in January. And I don't think it's been set for anything yet. Mr. Ames, if you know something I don't, but I believe that appeal is in process at the moment. So there's really not a lot to report. There was one additional case that just cropped up. It appears that OCD is going to handle that appeal as well. Give me 1 second on this one. Yeah, there's Jalapeno versus OCC in the Court of Appeals. So OCD counsel will be handling that appeal, not my office. And that's all I've got to report at the moment.
Clarification, the Office General Counsel will be handling it, not me personally. The office will be handling it.
Sorry about that. You're right. It's the General Counsel Department. My apologies.
And if I may interject here, this is Mike Felderword for Namoga. Obviously, we were involved in that effort. Who should we coordinate with in addressing the Supreme Court's request?
That'll be Bill Brankard.
Mr. Brankard, okay.
Yes.
Thank you.
All right, thank you, Mr. Melander. Is there any other business in front of the commission? All right, our next meeting is March 25th, 2021. And with that, everybody have a great rest of the day. Thank you.
Thank you, Madam Chair. Thank you, everyone.
Thank you.
Thank you very much. Thank
Bye.
you.